Let me talk a little bit first legally and why that's so significant. None of the other indigenous people across the globe exercise the sovereign rights that Indian tribes do. And the reason for that is because, in contradistinction to, let's say, the First Nations of Canada, the Maori of New Zealand, the Aboriginals of Australia, those indigenous people that were affected in the same way by discovery, the United States took a different attitude, a different legal attitude towards the Indian people. That's because the United States set up a different structure of governance called divided government, structurally separated among certain political groups. The states, for example, powerful, reserved powers in the Constitution. The people seen as the popular sovereigns that created the United States. The federal government seen as a limited government, exercising only what's called enumerated powers. So it was not too difficult for Marshall to decide that Indian people, as the first governments, as the first peoples of North America, likewise exercised inherent sovereignty, a sovereignty not granted by the Constitution, a sovereignty not given to the Indian people by the non-Indians, but a sovereignty inherent to the fact of their occupancy and ownership of America. That's the sort of key distinction. If you're going to talk about one key factor that sets Indian people apart from any other indigenous people across the globe, it's their unique political status under the law. If you look at, for example, how Aborigines are regarded in Australia under the Racial Discrimination Act of 1967, pursuant to the winning of Commonwealth status by Australia from the Crown, the British Crown. The Racial Discrimination Act in that nation describes the Aborigines as a racial class. The Maoris basically regarded as an ethnic class in New Zealand. The First Nations regarded under the 1982 Constitution, which severed the ties between Canada and England to make Canada independent country, regarded as sort of a mixed racial class with some treaty rights. But only in America are a group of ethnically defined peoples defined as political entities. You look at, for example, the pending bill brought by Senator Akaka in the Senate, trying to recognize Native Hawaiians as a sovereign people. Unfortunately, the background run-up to that bill, 1997 decision by the U.S. Supreme Court saying Native Hawaiians are racial and not political class, sort of stopping the idea of indigenous sovereignty at the seashore of the United States looking west. So the Native Hawaiians as a racial class will likely, in light of the Bush administration's vehement criticism of the pending Native Hawaiian bill, will never become recognized as sort of an indigenous political group like the Indian people. The fact of treaty making, which is sort of as well unique to the relationship between this indigenous group called American Indians and the United States, set them apart from almost every other indigenous group with some small exceptions. So sovereignty as a political legal concept is that core feature that really has created an opportunity, perhaps the only opportunity, that the Indian people had of surviving in a world that has grown, if not increasingly hostile, but seemingly indifferent to their survival.